Hello and welcome back to Questions That Matter. This is the show where we talk about all of the important and interesting questions that everyone at TrustBridge is working on. In an op-ed that he wrote for the website moneycontrol.com on the 2nd of October 2024, my colleague Dr. Prashant Narang talked about the latest government rule on arbitration. Specifically, this is a rule that prohibited arbitration on disputes that involved an amount more than 10 crores of rupees. Now, why do we care about this? This isn't a trivial change. This isn't a minor shift in policy. This is something that could potentially shake up the entire process of dispute resolution and affect investor trust in the public sector in India. Today, we have with us Prashant to take us through the details of this issue and explain why it's so important to us. Prashant, welcome.
Thanks, Bhavin.
Congratulations on the publication of the op-ed. And let's start by talking about what exactly the government decision was and why exactly is it such a big deal?
Let's talk about why this is a big deal. Private companies make these sort of decisions all the time, how to resolve their disputes based on what works best for them. It's a business decision for them, so they may choose arbitration, litigation, mediation. It's a strategic decision. But when the government asks all the PSUs to ditch arbitration, because it concerns public procurement, and given the scale and quantum of public procurement, it's a policy decision. It's a policy move which needs solid justification. And you see, there isn't much data available in public domain. I mean, are there any reports? Are there any numbers, data? Nothing. We know that PSUs are also not putting this kind of data, arbitration-related data, in public domain. In the name of confidentiality, these numbers don't come out. So we actually don't know what is broken or what is wrong with arbitration. Yes, in the office memo dated 3rd June 2024, government has listed some reasons, but to what extent these reasons are genuine? Do we have any numbers to back those reasons up? So the question is, are we asking the right question? Because if we are not asking the right question, how do we get the right answer? The risk is that this can slow down things in the entire economy, because not only it will shake investors' confidence, business confidence, it may hurt overall economy. So it may not hurt the government, because the government is responsible for public procurement, but it may harm private businesses who depend on government, on PSUs, on other departments for timely payments. So if it hurts the economy in the long term, I don't think that the price that anybody would like to pay. As a country, we want to see India as the arbitration hub. And on one hand, we want to invite businesses from other countries to come to India and to undertake arbitration here. And on the other hand, we are telling our PSUs, the government telling its PSUs to not engage in arbitration. So that's a paradox. So on one hand, if we want to improve ease of doing business, we must have a correct diagnosis of what's broken, what's not working well, and then try to look for solution, which means it has to be a data-backed, evidence-driven solution.
So I think there are two really important things that you've pointed out for us, Prashant, and I just want to take a moment to emphasize them a little bit. The first is you've identified for us that things aren't as easy to diagnose here, because arbitration is, shall we say, a private dispute resolution process. It's not like a court resolution where the outcome is publicly available. Very often the proceedings are easy enough to find, and so we have much more information on the basis of which to make up our minds. But here we're operating in the dark. All of this information is with the government, it's with the PSUs, but it's not available to us as external researchers. And so we don't know the basis for this decision. On what grounds and what data has this decision been taken? And I think the second important thing that you pointed out is that this isn't just a narrow question of dispute resolution. We're talking about public procurement, we're talking about contracts with the government, and these are contracts with a private party on the one side and the government on the other. Anyway, the scales are tilted, anyway, things are a little skewed, and so if you change things in this sort of fashion, it's very likely that people would not want to enter into these sort of contracts. And so, as we said, it's not just dispute resolution, but projects come to a grinding halt because nobody wants to enter contracts into or work with the government. Now, having said all of this, let's give the policy decision the benefit of the doubt. They have offered alternatives. They do say you could go for mediation or just go with standard court litigation. How realistic are these alternatives?
Yeah. So let's take a look at these alternatives. So first is mediation. The data shows that most parties flat out reject mediation in commercial disputes. So if it's not working for most parties, then how is it viable? Is it viable? Probably no. Government has proposed constituting high-level committees comprising of retired judges and technical experts to handle large disputes. So the committee would look at the disputes to suggest settlement terms. The question we need to ask is, has it worked anywhere? Has the government tried it anywhere? Have they experimented? Is there a case study? We don't know. They have not tried it. Otherwise, they should put it again in public domain if they have tried it, if it has succeeded, if it has worked somewhere. So experimenting is good, but they should first start with a pilot study instead of rolling it out nationwide, because that's risky. Now coming to litigation, again, the data shows that after the enactment of Commercial Courts Act, the disposal rate has actually dropped by more than 20%. So it seems that the courts are even more clogged. So is it a good idea then to go back to litigation? And we see that in the policy proposal, they have mentioned that they would be going to institutional arbitration for smaller disputes. So the question is, then why not try institutional arbitration for all disputes?
Wow. So, Prashant, I think you've done a very solid job of identifying what the scale of the problem is and what this could lead to. But our job doesn't end there, and we've got to try and think of ways out of this situation. So, in your opinion, then, how do we move ahead from here? What's the future of dispute resolution?
Yeah. So, let's first also talk about the appeal rate in PSUs. Everyone knows that the appeal rate is very high. It could be fear of scrutiny or other incentives that public officials tend to challenge every unfavorable award. And the lose rate is also very high and the win rate is low, which means that a lot of awards that shouldn't have been challenged in the first place gets challenged. This culture and those incentives need to change. Secondly, we need to have data-driven policy. We need to have public consultations, stakeholder consultations before government comes up with such a large-scale policy change. Because policies are made in public domain and not in secrecy. If you really want to see India as the hub of global arbitration, we really need to first understand where the problem lies. So we need to have an accurate diagnosis of the problem and then look for solutions.
Understood. And I think it's very useful to remember that we can't make those decisions unless that information is available to us. And as you said, policy is something that should be made in the public domain and not in the private realm, not in secrecy without information. Thank you very much, Prashant. The link to the op-ed that we've just discussed in this video will be available in the description. I'd encourage all of you to please go read the op-ed for yourself, make up your own mind. But one thing that I want to make up your mind for you is please do come back, watch more of these videos and support our work. Thank you very much.
Thank you.